So thank you all so much for joining us today. My name is Emily Kile, and we try to do these webinars once a month, and we get a lot of outside speakers so that we can get information that you wouldn't hear from our office. So I'm absolutely thrilled today to have Hope Kirsch and Lori Kirsch Goodwin give us a presentation on navigating the world of special education. We've known each other for a very long time, refer a lot of clients back and forth who have different needs. And it's always great when we have live presentations because we have a tendency to be at similar programs. So it's always good to see everybody in person. So just kind of a brief background. I won't go into all the detail, but Hope is a licensed special education teacher and attorney, and she advises and represents students and their families throughout. Oh, she's right there. So you can see the information about Hope. And then do you have one for Lori as well? So I don't have to read everything. Oh, perfect. It's just part of the materials. So this is being recorded, and we will get the materials out to everybody if you don't have them already. And with that, I'm just so grateful that you guys are willing to give up an hour of your time today. And I will let you go ahead. For attendees, I think you're all muted. So at the end of the program, we're happy to take questions, or you can type them in the chat or the Q&A box. And so as those come in, we can try to answer them for you. Thank you all. We hope that you are well, and I will leave it to you guys to proceed forward. Thank you so much.
Thank you, Emily. And thank you for being there for our clients who need guardianships and conservatorships. You're just a phenomenal resource, and everyone loves you. As far as our background, we're basically litigation attorneys, trial attorneys, and we went to the good side of the law of helping students and their families. And that's all we do. We work with students and families. We do not represent teachers. We get calls from teachers a lot. We have to refer them out. So, and the difference between Lori and me, and we're sisters, is other than our ages. Lori is the parent of an adult, a college graduate on the spectrum, and she helped him navigate through the whole special ed process, even from when she was told by a neuropsych in town, nope, he's never going to be on his own. He's now a teacher, an English teacher. And I was a special education teacher and school administrator in New York for 18 years. I don't do the math anymore because that would tell you how old I am. So we just drop all those years. All right. So basically, we're going to be talking about how to navigate the system. Oh, here's our disclaimer. We're not giving you legal advice. This is general information. If you ask us a question, it's general information. We cannot give legal advice. We're just not allowed to unless you're a client. So if you actually need legal advice, you have to go seek an attorney. So we're going to be talking about the different laws that impact students with disabilities and their families, how to identify and evaluate a student for either an IEP, which is an individualized education program, or a 504, IEPs, placement and location, that's a distinction that people are unaware of, and what to do about disputes so that you don't need to go to an attorney. So first we're going to talk about early intervention. These are for the little people, basically infants and toddlers from birth to age 2. There are great services in Arizona. So Arizona is not known to have great schools, but it does have great early intervention services. Lori had it for her twins, and it's under what's called Part C of the Individuals with Disability Education Act. That's the IDEA. And Arizona has the AZIP program, which is Arizona Early Intervention Program. If you think that if you have any concerns about your little person, then you go online and you search for AZIP, AZEIP, and they will test your child for free. And if your child qualifies, your child could get into a developmental preschool. If your little person doesn't qualify, and it's usually for speech, motor issues, stuff like that, then just monitor your little person, and maybe when they become school age, that's when you start to see a few more problems. And it's a statewide system, and it has all these services and supports for little people. Laura, you had massage therapy and
I
physical
had
therapy.
everything for my guys. They were 10 weeks early, so they got right on board.
She had respite hab. So it's for any child with a developmental disability, and that's defined as a child that does not reach at least 50% of their developmental milestones for their chronological age in one or more of these categories. Physical, which is the fine motor, the gross motor, vision, hearing, cognitive, which is your intellectual development, and language, speech, social, emotional health. So it could be, I remember one of your little people used to like throw things around, and so very aggressively. Yeah. Okay. He's fine now. So these are the areas in which early intervention services are provided, the same ones I just said: physical, cognitive. People will always come to your house, and then we would take off on Fridays when I visit, and we'd run to the physical therapist and this one and that one. So lots of great services. Early intervention really is the key. And so it's through the Department of Economic Security. Here's the website for you to contact them. Okay, so now we'll just talk about the laws impacting students with disabilities, basically for when they're school age. All right, and these affect students with disabilities under the IDEA, the Section 504 you've heard of. It's actually called Section 504 of the Rehabilitation Act of 1973, but you could say Section 504 or 504, and the Americans with Disability Act.
IDA is a law ensuring that services to children with disabilities are provided throughout the nation. IDEA governs how states and public agencies provide intervention, as we discussed, in special ed and related services under IDEA Part B. Section 504 of the 1973 Rehabilitation Act contains a much broader definition of students with disabilities than the IDEA, and thus protects students with disabilities who may not qualify for an IEP. So if you have a disability, your child has a disability, they will most likely be entitled to 504 protection. They may or may not be entitled to IDEA, which is specialized instruction, and that's a determination. So even if they have a medical diagnosis, for instance, of autism, that would allow them to have a 504, they may not need specialized instruction, so they may not be entitled to an IDEA.
IEP.
Or an IEP, an IEP. Thank you. So the ADA increased the number of individuals who are eligible for protections and services under both the ADA and Section 504 of the Rehabilitation Act of 1973. An impairment in and of itself does not mean that a student has a disability. There must be a substantial limitation on one or more major life activities which results from the impairment to be considered a disability under Section 504 and entitling a student to FAPE, free appropriate public education. The term place of public accommodation for the purposes of Title III of the ADA specifically includes a nursery, elementary, secondary, undergraduate, or postgraduate, private school, or other place of education. Private schools are obligated to comply with Title III of the ADA, regardless of whether they are covered under Section 504. Under the ADA, private schools are required to make reasonable accommodations and provide auxiliary aids and services to ensure that students with disabilities are not excluded, denied services, segregated, or treated differently than other students. Title III defines discrimination in part as, quote, the failure to take such steps as may be necessary to ensure that no individual with a disability is excluded, denied services, segregated, or otherwise treated differently because of the absence of auxiliary aids and services, unless the entity can demonstrate that taking such steps would fundamentally alter the nature of the good, service, facility, privilege, or would result in undue burden.
So what this means is if your child goes to private school, not a parochial school, that's separate, but a private school, not an Arizona Department of Education approved private day school, but a private school, the school must provide accommodation. So if your child has a learning disability, they don't have to modify any instruction. They don't have to change the instruction. So that child would not get services unless the private school just wants to, out of the goodness of their heart, to give services, but the school is not required to do so. But usually it's for a child with ADHD, where the school would just provide a quiet place to take a test or extra time. Okay, so now we're going to talk about the IDEA, which is the Individuals with Disability Education Act. And so again, like Lori said, that's the nation's special education law. It's for little guys from 0 to 3, that's Part C, and then Part B is ages 3 to 21. In Arizona, you can go to school until you're 22 if you have not received all of your credits, if you have an IEP, not a 504, but an IEP. Sometimes schools will try to give students their credits when they're not deserved, and so they should not do that, because a kid can be entitled, if they have an IEP, to stay in school until the year that they're 22.
So we urge parents to look to see how many credits their child has by their sophomore year, to see if they're on track to graduate, if you want them to graduate, and if they're not, or if they are on track to graduate, but you think that they need more time in school to learn some other skills and meet some other goals, scale back on the credits so that they don't get them at the end of their senior year.
And sometimes they'll, like, I hate to say it, dummy down the work. It has to be aligned to state standards. So it's got to be pretty ambitious goals. So the purpose of this law is to provide a FAPE. FAPE is a free and appropriate public education. Free is important because that means that if your child needs, for instance, a Chromebook, you do not buy it. The school is obligated to provide it for you. You don't pay for any services. That is also why sometimes parents will say, I want my own provider in the school. I'll pay for it. No, schools are not allowed, aside from liability, they're just not allowed to require you to, or even gratuitously allow you to do anything that's going to cost money out of pocket. So it's to provide a free and appropriate public education, a FAPE, in the LRE, the least restrictive environment, to prepare students for further education, employment, and independent living. Meaning, if your child is doing well academically, but isn't making any friends, and is getting into a lot of fights at school and is being disciplined, then that child has or may have behavior and social or emotional problems, because kids don't just get into trouble. They don't have these infractions unless something is going on. Okay, kids are just not bad. My background is teaching students with the emotional disabilities, and they were kicked out of every other school because of aggressive behaviors, but they had emotional disabilities that they were dealing with. Special education is SDI, specially designed instruction. And that is changing the content, methodology, and delivery of instruction. So for instance, my typical example is if a child is in 9th grade and needs extra time to read Romeo and Juliet, that's just an accommodation. The child is expected to read the book, understand it, take a test. But if the child is reading at 3rd grade level, then the school has to adapt the content. So it's not actually Shakespeare they're reading, but they're getting the concept of it. Maybe in cartoons are being presented. It's in a comic book fashion with 3rd grade level words. And so then you're changing the content, methodology, and delivery of instruction. Lots of times parents go to meetings and they want an IEP, and the school will say after an evaluation, you know what, all your child needs is accommodations, and so we're going to give them a 504, but not an IEP, because they don't need specially designed instruction. And that's where you need to say, yes, they do. But you can't just say, yes, they do. You have to give examples of that. So special education is not only specially designed instruction, but it is, as I said, free. It's at no cost. It's designed to meet your child's unique needs, and related services are provided as well, which related services are anything that enables a child to access the curriculum, such as speech therapy, could be vision therapy. Yeah, some of you at home are probably going, vision therapy? Ooh, the school didn't tell me that. But yes, anything that your child needs, physical therapy, occupational therapy.
To access curriculum.
Curriculum. And where is it provided? That's where we get into location and placement. We'll talk about that. And the dollar signs means that the schools get money from the federal government funneled through the Arizona Department of Education through federal and state legislation. It's called spending legislation. It has teeth. It has to be monitored. That's why you have all those papers. Schools get money and they can lose money as well if they don't comply.
So eligibility, in Arizona, a child with a disability is defined as a child who is at least 3 years, but less than 22 years of age, that's in Arizona, who has been evaluated and found to have a disability. And because of that disability, they need special education and related services. So they need that specially designed instruction.
Right, so they can have a disability and not need the SDI, such as a child with autism. They don't all need specially designed instruction. So what triggers the initial evaluation?
So a request by a parent can trigger it. A request by the school can trigger it. And in fact, the school has an obligation, it's called child find, to be looking for any child and has to look at all children and try to find those children, even if they're not in school, that need to be identified and evaluated. So if a parent makes a request, they have to respond to that and have a meeting to discuss the existing data and decide whether or not to evaluate. Or a school can ask a parent for consent. And either way, the parent has to give written consent to allow for an evaluation. The request can be made orally, but the best practice is to make it in writing. So we always tell parents, send an email. And that also helps track the timeline so that they know within 15 days, they have 15 school days, they have to have a meeting to go over the existing data and just decide. So there were no real trigger words, just something like, even if a parent says, I'm kind of concerned about him, is there something we can do? That's probably enough to say it was triggered. But you want it to be in writing if possible, so that you can argue, if needed, that you did make the request on such and such a date. 15 school days is coming up, and you want to have that meeting. So there's no real magic words. It's just a matter of just getting out there that there are concerns and they want to evaluate.
And because you were here today, even though you're not required to, please say, I want my child assessed, evaluated, tested. And if you could say for an IEP, for special education related services, that's even more perfect. So a word about child find that Lori mentioned. So basically it's the obligation of a school district or charter schools and public schools to identify, locate, and evaluate a student who has a disability, suspected of having a disability, but also suspecting of needing specially designed instruction. We are seeing a pullback lately from schools. Oh, I didn't think that child needed that. No, I thought maybe he had autism, but no, I don't think. He was just doing fine in school, making friends and all that stuff. We never suspected a disability or never suspected that he needed specially designed instruction. So even though a child is advancing from grade to grade, that doesn't mean that the school is not obligated for child find, because if they're advancing from grade to grade, because schools usually do that, but they're struggling, that could also be, see the red flags, for a school to suspect a child of having a disability.
Keep in mind that a FAPE isn't just educating the child while they're in school. A FAPE also means that the schools are getting ready right from the get-go. The child's getting ready to graduate, transition, become an independent adult, and work independently. So, or go to the next level of education. So those things include, behaviors and socialization. It's not all about academics.
And so here are your red flags. You want to ask for the 45-day screening. I wish we had a live audience because they'd say, who knows what that is? And I don't think there would be one hand raised. So within 45 calendar days of your child entering school, if they never had an IEP, or if they don't have an IEP, the school must screen them in areas such as cognitive, the intellectual functioning, how are they getting along with everyone? What are their motor skills like? And then if there are concerns, they're referred to either the school study team, or it could be that they're actually referred for an evaluation. You want to see that 45-day screening. So,
And the 45-day screening isn't when you first enroll in school. It's if you move schools or transfer and you don't have an IEP.
Right.
So your child goes to a new school or a new district,
mhm.
they have to do that 45-day
Right.
screening.
Child in 5th grade transfers from Scottsdale Unified to Chandler, they have to do a 45-day screening. You're also going to look at email. Ooh, I love emails. They will tell a story. Mrs. Jones writes to mom and says, you know, Johnny's not bringing in his homework. Oh, Johnny's not listening. Johnny's really having a hard time. And then the teacher, the mom writes back to the teacher, I can't get the kid to do the homework. He doesn't bring home his homework. Where's his homework? Oh, his book bag is a mess. All that stuff. Those are red flags that signify that the school should suspect the child has a disability and may require specially designed instruction.
You should be asking the parent for a consent to evaluate.
Yes. And so what areas have to be evaluated? Let's just say everything. Everything in which an area of a disability is suspected. So actually, if your child is just, I mean, not you don't have to test for everything. For instance, just schools won't test for autism unless they actually suspect autism. Okay, so that's one example. But they're looking, you have to have that, you know, the health, they'll ask you how this, they won't assess for health, but they'll ask you what your child's medical history is. But schools have to do the vision and hearing screening. And then the social emotional status, that's done by observing the child and by surveys that you get home, where you and, you know, the parents will be asked to fill in these questions. Does your child do this all the time? Never, sometimes, you know, clean the room, do the homework, scream, play with others, stuff like that. General intelligence, that's the IQ test. Academic performance, how are they doing in school? Communicating, how are they talking? Not just the articulation, but the pragmatics of going back and forth and looking at the motor abilities, the handwriting, the gross motor, jumping, running,
Opening a door.
right. And so these are how the schools evaluate like I said, IQ, academics. They look at standardized test scores, and then they'll conduct psychoeducational tests. That's usually by the school psychologist. Charter schools don't usually have them on site as employees, so they will contract someone on the outside observing the student. And I want to see, this is, oh my God, I want to see the student observed across multiple settings, different days of the week, different times, before lunch, after lunch, and unstructured settings such as recess. I don't want that child observed just in math because that child loves math but can't read at all. I want that child observed in all the classes in which they struggle, not just the best class. Interviews of parents, that's usually the surveys. Sometimes the student is asked to rate themselves. And so these are the areas of eligibility. It's set forth in ARS, is the Arizona Revised Statutes. And so there are 14 areas. The federal government lists 13. We have 14. They all have those acronyms. Okay, sometimes you can have 2 of these. You can, there's some that you can have together, like autism, emotional disability, even though you think, oh, this kid has autism, but this kid has an emotional disability. It's one or the other, so it's which is more dominant. Then you have primary and secondary, so you can have speech and language impairment along with specific learning disability, but which is more pronounced for that kid. And that's what primary is. Okay, so what if you disagree, Laura?
Yeah,
What if you disagree?
What if I disagree?
With the
Well,
evaluation?
if a parent disagrees with the evaluation, they can ask for an independent educational evaluation. So they just ask for an IE. Well, we'll get to what happens once they ask, but that's what they would do. How do you request it? Again, you can ask, but you really need documentation. So ask in writing. Again, there's no magic words other than saying, I want one. I want an IEE. When we're advising clients, we usually say, you know, we disagree with what was in the report or the evaluation. We don't see our child like that. We see different things, so we'd like an individualized education evaluation. Now, a school can ask why, but a parent doesn't have to answer. So a parent could say, I don't have to tell you why, I just want one. We don't recommend that. We recommend to say something in line with what I just said. You know, we don't see what's in there as accurately depicting what we see. So what does the school have to do? They have two and only two choices. One, they say, sure, go get an independent educational evaluation. You pick who you want. They could give you some names of people that could do it, but you don't have to use them, and they'll pay for it. That's number one. If they don't do that, they have to file a prior written, well, they have to file a due process, and they give you a prior written notice either way, but they're going to file a due process. Those are the only two. They can't ignore you. They can't.
Well, they can.
Well, they can.
And then
but
you
then we
file
sue
due
them.
process.
Right. But they're not supposed to ignore you. Those are the two and only two. So they have to get back to you. And when do they have to get back to you? Right. Reasonable
30
time.
days.
You give it 30 days. I usually start bugging them after 2 weeks, but you know, outside of 30 days, I don't think that's reasonable. And at that point, you'd have a claim too, but they should have either provided an okay or file due process.
Now, you may not agree because you don't agree with the conclusion that, say, for instance, your child doesn't have a disability. That's not a good enough reason. In that case, I'll look at the evaluation. If anything sticks out that is not reasonable, that they didn't test in all areas, that there's conflicting data, I would feel comfortable requesting the IE. If I'm not sure, then I will ask you to take it, or if I can take it to an outside school psychologist to review, and have that person review it and tell me what is deficient about it. I want to know if the school, if they filed due process, would they be able to defend their evaluation? So it's not always, you know, years ago, we would have said every time you request an IE, schools say, yeah, okay, just go do it. Now they're pushing back and filing due process. So I want to make sure that there is a deficiency in their evaluation. Okay, otherwise I'm not going to feel comfortable defending that. You know, when I say defending, they have to defend their evaluation. I wouldn't feel comfortable representing a parent who would have to then say, no, it was deficient.
And possibly filing a counterclaim. But before you go on, just one quick thing about that. Something that else that's changed in recent time is a functional behavior assessment. That's usually if there's behaviors going on, you would ask for an evaluation of a functional behavior assessment.
Still
We're gonna
doing
get to it?
No, you still can. There's a court case on the east side of the country that says that an FBA is not, a functional behavior assessment is not an evaluation, you're not entitled to an IE,
Right.
but that hasn't been settled out here, so schools are honoring those requests.
Always?
It depends on who the attorney is in
Yeah,
the school.
not always, but yes, that is an issue just to be aware of.
Okay, so here's the sequence. You want to request an evaluation, which you're going to do in writing. The school has 15 school days to either say, because this is another pushback we're seeing, another trend, either convene the meeting to review existing data, that's the red meeting, or to issue a prior written notice saying, no, we don't even suspect a disability at all. Schools are pushing back on that. The reason is because once you have a red meeting, if the school then says, we've reviewed existing data, we've reviewed the data, there is no reason to evaluate your child doesn't have a disability, you can then file for request an IE. You cannot request an IE if they just say, no, we're not going to evaluate. So that's the trend we're seeing. Once you request that, the school has to issue a prior written notice acknowledging that you requested prior is misleading because it's a notice that comes after a decision is made, but before implemented. So, okay, mom has asked for an evaluation, and so we are going to have a red meeting. Okay, so that would be the prior written notice. Then another prior written notice after the red meeting, we met and we are going to evaluate. And at that meeting, you will have to sign that evaluations. It has to be written, signed consent. They can't just evaluate your child without that. A screening is not an evaluation, by the way. So when it talked about a 45-day screening, that's just looking at your kid. Screening is something they do for everyone. An evaluation is individualized for your child. You must sign that. So sometimes we get calls. They evaluated my kid. What they do? Well, they tested him, you know, in reading, but they tested everyone. So that is, if they're testing everyone, that is not an individualized evaluation for which consent is required. Okay, so then you sign the consent. Then from that point, the school has 60 days to complete the evaluation, 60 calendar days to complete the evaluation and meet with
So
you.
let me just go back one step. When you consent to evaluate, if you're at a meeting, in COVID, it was difficult because you weren't live, but if you're in a physical meeting, ask if you can sign it right then and there, because that starts the 60 days ticking, as opposed to them saying, okay, we'll get you the consent, and so they could waste another week by the time they get it out to you and get it back. So
Good point,
just
good point. Or say, send it, if it's by Zoom, just say, or Google Meet, say, send it to me today.
right.
And I also want a prior written notice that you agree to evaluate today. I wanted to say, we met on September 14th and you said, yes, we're going to evaluate. Okay, 60 calendar days, again, a meeting notice before that meeting, prior written notice afterwards. You're gonna have like stacks of these prior written notices. So it's 30-page booklets that you're not gonna read because no one does, but you should. But even if you do, you won't understand it. Okay, if the child's eligible, you have to have an IEP meeting within 30 calendar days. Again, you'll get a meeting notice and a prior written notice. If the school thinks they're gonna find your child eligible, then they may say, we're going to have the eligibility meeting. And if your child is eligible, we'll go right into an IEP meeting. That's not predetermination. They're not allowed to predetermine. They're not allowed to say, yes, your child is eligible, or no, not until they meet with you. I'm talking fast because we only have okay. So what is a day? We talked about days. So you have calendar days, which is straight days, including Saturdays, Sundays, holidays. Or school days, that's just days when schools are in session, versus business days. Business days occur during, for instance, the summer, during spring break, during winter break, just not holidays. Any day the bank is open is a business day. Okay, so 15, 30, 45, those are just, 15 days for the evaluation, for the prior written notice, the red, then 30 days for the IEP, 45 days. Oh, we didn't get into 45 days.
And 60 days too, which is for the evaluation.
Right, so 45 days comes, that has to do with discipline. All right, so notices, procedural safeguards notice is a 30-page booklet. Again, you should look at it anyway. Meeting notice before a meeting, so you know who's coming. Doesn't have to say names. It shouldn't say names only because, like, if it says that Emily is a school attorney and she's going to come to the meeting, and Emily goes and wins the lottery and she decides to close her practice, it would be a violation if she's not there. So they'll just say school attorney or psychologist. And the prior written notice after the meeting. And it has to be within that day or the next day. They can't give you the prior written notice when you walk in. Okay, now the IEP. I do talk so much faster. Okay. Oh, I'm so excited for IEP meeting tomorrow. Said no one ever. Okay. So who has to be there?
The parents have to be there. Absolutely, parents have to be there. I don't know if I can repeat this enough. The parents have to be there. General ed teacher, a special ed teacher, does not have to be your child's special ed teacher or general ed teacher. It should be best practice, but does not have to be, as long as they have a general ed or a sped. Sometimes they try to have one person because they're both a sped teacher and a general ed teacher. A district rep, an individual to interpret the instructional implications of evaluation results, usually the school psychologist, and discretion of the parent or the school district to say, we have somebody else we'd like to join. They have knowledge or special expertise regarding the child. That's really important. Sometimes we'll invite someone and I'll look at the meeting notice and I'll say, who's this person? And why are they going to be there? Because they are supposed to have knowledge or special expertise regarding the child. For a parent can bring anybody they want, pretty much. They could bring a neighbor, a friend. They could bring an attorney. However, they have to give notice that they're bringing their attorney, because then the district would also want to have their attorney there. So that's the only caveat. You can bring an advocate without telling them, but not an attorney.
And the child only when appropriate.
Right.
And
The child should be invited though.
If you think you're gonna fight, don't bring the child, or have the child come at the beginning. I know schools will say, oh, he's so well behaved, he doesn't, he never caused any problems, and he's got severe ADHD. Oh yeah, I want him at the start of that meeting, just running all around the room. And you tell me that he doesn't need specially designed instruction. Okay.
And if it's an older student, you want them there, especially high school, because they have to buy into this IEP. You could prepare a great IEP, but if they don't want to follow it, you're gonna have a problem.
So this is the parts of an IEP, present levels of academic achievement and functional performance. See, that's not academics, that's functional. How are they functioning behaviorally, socially? And then you need goals. The goals have to be SMART, they have to be specific, they have to be measurable, they have to be actual or active. What is the kid going to do? They have to be realistic, and they have to be, when does this goal have to be met? And usually it'll say a year from now. How progress is going to be reported, what's the services. So we always match up the goals. For every goal, I want to make sure there were service minutes. That's the service page. What are the accommodations and modifications? What's the LRE explanation? We're going to talk about that. Where the child is going to be placed, and then if the child's eligible for extended school year. If it's November, you don't know if your child's eligible. I've seen IEPs written in September, your child's not eligible. You don't know if your child's eligible because there's no data to save. Data has to be taken before and after school breaks. And if a child is going to be 16, you want post-secondary goals and transition services. Sorry, I'm talking so fast,
No,
but
I know.
these are the SMART goals. This is especially design instruction that we talked about before. These are certain accommodations that are made. Remember, you're not changing the content, methodology, or delivery of instruction. It's just whatever's needed so the child has equal access to educational opportunities. Think of a child in a wheelchair. You need a ramp to access the classroom. Okay, so you're not changing what the child has to know, just giving them the same access as other access to education, to put them on a level playing field. These are the related services that are available. This list is not all inclusive. Vision therapy is not listed on here, so it's anything. It really is anything that a child needs
To access the curriculum.
And if you come to us and you say, I want what's best for my kid, we say you're not entitled to that. There was a case many years ago that in the Supreme Court that says your child's only entitled to a basic floor of opportunity, only an educational benefit. And so for years, what is that? What kind of benefit? A lot of benefit, a little benefit, a lot of, and benefit just means progress. Fancy word for progress. Child has to make a lot of progress, a little progress. In 2017, there was a case, and the Supreme Court was asked, how much progress? But there was no clear answer. It just said that the IEP has to be appropriately ambitious in light of the child's circumstances, meaning that if a child is low functioning, has a lower IQ, you still should make it pretty ambitious. What should the child be able to do? I have a parent who years ago, the child really was totally nonverbal, very low functioning. She just sent me 3 YouTube videos of the child reading. We never, ever thought that. And, went to a private school helped. And so whoever thought that? No one would have ever thought that. And so that's an appropriately ambitious goal. Okay,
So there's levels of placement, and it's a continuum. You shouldn't jump from A to D. Sometimes there are circumstances that would allow that, but usually it should be a continuum. Children should all be assumed to start in a regular class. They're outside of the class very, very little, less than 21%. That's level A. And that's what most students, general ed students have. Level B is if they need some pullout. So they need maybe help in math or English or both, but the time that they're out is, is 40% to 79%. But otherwise they're receiving instruction in the general ed classroom with their general ed peers. If a child needs more than that, and there could be push-in services where they actually push services in. They'll bring in a speech person to help while the child's still in class or someone to help with math. But if not, then the child has to be pulled out. And as long as they're not pulled out more than that 79%, then they're still level B. Level C is a self-contained classroom. That's where the student just is not going to do well in any of the general ed classes. Now, that doesn't mean that they're not going to go outside. They could still go outside of the class for specials, art, physical, PE, things like that. But for the most of the day that they are in with a special education teacher and other special ed students. Then there are the children that can't do well in that atmosphere either and really need a private day school, a separate day school. And sometimes public schools have these separate schools, even though they're not private, but that's another building. It's separate and apart, and they're not with,
Not always a separate building, but
well, it's actually the definition says separate building, but it's supposed to be, and they're not going to see any regular ed students most likely throughout the day. So that's D. Then the next is a residential treatment center. That's for kids that need to go away. And you know, they stay there in these centers, they get educated, but they also get other services for whatever their needs are.
and my point is they're always, it's all encompassing 24/7 to educate that
Intertwined.
kid.
Yeah, it's so intertwined, and then we can ask for placement by the district.
And then beyond that is like home instruction, which is the most, really the most restrictive because the child is not with any other children. So
Or homebound, a little different, but yeah.
we had a question from a very well-respected advocate, and she wanted me to point out that if an advocate is going to the IEP meeting, it's not required that you tell them. It's not even required that you tell if you're bringing an attorney, but it's just courteous. And so you should, but you don't have to. And then there's sometimes where I say to parents, don't even say you're bringing an advocate, but that depends. And then as far as recording, New York, Arizona is a one-party recording state. You don't have to say you're recording. It looks better if you do. I don't want to have to deal with the attorney who says, oh, help, your parents didn't tell us they were recording and they were recording. Just tell them. And the bottom line is that you don't want to have to take notes and listen. It's easy to record. You're going to forget what someone says, or maybe the child's other parent isn't there and you want to play it for them. Like when people meet with us, I always say record it, if I remember to say it, but you should record it, but you're going to forget what I say. And I talk kind of fast. So it's good to be able to go back to that. And then of course, even if Lori and I hear something, we don't always agree on what we heard. This way, if it's recorded, we know. If you are an attorney, beware. Even if you're an attorney going as a parent, you must disclose your recording. Did you know that, Emily? That we're not allowed to, there's an ethics opinion. Even when Lori would go to her meetings, she was not allowed to surreptitiously record, no matter what role you're playing. I have that ethics opinion, so. But, you know, you want to be forthright. You want to be forthcoming. And if I go to a hearing and there's a judge, I want the judge to know that the parent told everyone they were recording. Okay. I love state. Don't you love state put? Okay, talk fast because we have.
So if something's going to change and the parent doesn't want to change, it's a placement. Well, we're talking about placement now. It could be in other things, but with placement, if the school says, you know, your child's been doing really great at this private day school, but now for next year, we're going to put him back in the public school because we think that, you know, he doesn't need the private day anymore. And a parent disagrees. They can say, well, I'm going to invoke state put. You can't change. They then have to file due process fairly quickly. They file due process. In the meantime, while the case goes to a judge and or an appeal and or another appeal, could be years, the child remains in the private day school. Could be vice versa. The school wants to put the kid in private placement and the parent wants to stay in the public school. Stay put. Until that time, the child gets to stay, unless the parents agree with the school otherwise. But otherwise, just everything stops. That IEP stays in place the way it is. Everything stays while it goes to decision.
Lori had that. Lori, she wanted to, the administrative law judge, the ALJ said, yes, the school's placement is inappropriate, location is inappropriate, location was inappropriate. And so the child had his, Lori got to pick the location. And then the school appealed it, went to the district court, who overturned it, but Lori then appealed it, so the child stayed where they wanted the parent, where the parent wanted. Ninth Circuit said, yeah, Lori, you were right, your parents were right, and so that was years.
Yeah, and even if I had been wrong or have been found wrong, they can't then collect reimbursement. It's done. So during the stay put, whatever is done or paid for, the district can't then go back and collect, even if it turns out that they're overturned.
So now we'll just briefly talk about the 504 and the Americans with Disability Act. The difference between basically an IEP, which is under the IDEA, and the 504 is, again, you get the IEP for, you have to have one of those disability categories, but 504, all you need is a mental or physical impairment that substantially limits a major life activity. Schools do not get extra money for that, but they can be dinged. If your child has a 504 plan and it's not being followed, you can file a complaint with the Office of Civil Rights of the United States Department of Education. You would just Google that. You can also file an OCR complaint if the IEP is not being followed. You cannot file getting into a due process complaint for an administrative law judge to hear if you just have a 504 though. Okay, the big one is discipline. So that's the biggest difference. If a child has an IEP and they are IEP or 504 and they're going to be suspended more than 10 days, school has to have a manifestation determination review to determine whether the infraction was substantially caused by or related to the disability. If they find it was related, the child stays in school. If they find it wasn't related, a child with a 504 can be long-term suspended and even expelled without services. Fine. But if they have an IEP, the school has to provide services, okay? And they can't be expelled, only long-term suspended, but they have to be provided special education services and access to the curriculum, which basically means an alternative school,
Online.
Private school, yeah.
It could be a change of placement, but they still have to get service.
Now, we have been inundated with discipline cases this year. Increased a lot last year. This year, just unbelievable. I had 5 due process complaints filed already in the past 8 weeks. Yeah. And all having to do with discipline, Okay. Difference between ADA and 504, both prohibit discrimination. So 504 is only if the school receives money. ADA extends to private. I always say, think of Starbucks. Starbucks is a private company. They have to provide wheelchair accessibility. They have to provide the handrail bars in the restrooms. Okay, so that would actually be Title III. And these are the differences in a free and appropriate public education under an IEP and under Title II. But basically, a FAPE under an IEP is the child's, comparing the child to the child's himself or herself. Whereas 504 is giving equal access to the child in relation to everyone else. I'm just going to scoot through these. This is, Lori already talked about a 504 and how it's defined, the disability. And these are the things it has to impact. Just about everything.
Yeah.
You do, just about everything. So all this stuff too. So you're talking about kids with diabetes. So a lot of the health issues, diabetes, epilepsy, attention deficit disorder, anxiety, depression, that could fall under a 504, or if it's severe enough to impact a child's actual accessing the curriculum, then the child will be eligible for an IEP under the category of other health impaired OHI. And this is what's included in a 504 plan, explaining the disability and what the accommodations are. This is what a typical 504 plan might look like. Every district has its own forms, but it says how it impacts the child and what the accommodations are and who's responsible for the accommodations. I love when it just says the kid now. Yeah. Kid, parents, but it should also have the school. School's responsible for that. Okay. This is for children with ASD, so autism, spectrum disorder and sensory issues. These might be good accommodations. The fidget toys, that's good for anyone with anxiety too.
Chill
Yeah.
out space. Kid needs time to cool down. Maybe even before they know that it's something's going to trigger them, do it before, so you're not just de-escalating, you're trying to stop it.
I just saw a TV show the other day, and this kid was getting on the bus, and the coach said, "You can't chew gum." He says, "Oh no, I can. It's an accommodation for my anxiety." Okay, and miscellaneous. Oh, we might finish on time. So these are just examples of discrimination for which you can file an OCR complaint. You can file a due process. Okay, so basically we file, just so you know, due process complaint is what we call special education lawsuit that's filed in the Office of Administrative Hearings in Arizona, heard by administrative law judge. There are 4 judges who are assigned to hear these cases. They have training in special education. And then appeals go to state court or district court. If it's just a 504 issue or a disability discrimination issue, then you can file an Office of Civil Rights complaint. Quick, easy. You don't need an attorney. You don't need an attorney for a due process complaint, but good luck with that. It's overwhelming. It's just overwhelming. Bullying and harassment is an example of discrimination. If a child, and I had a call today, the kid doesn't have a disability, and those are hard because even though Arizona has anti-bullying statutes, they have no teeth. Schools don't get money for that. There's no oversight. The statute, Arizona revised statutes, require school districts to have anti-bullying policies. I call it the so what. So what? It's there. Nothing you can do unless and until a child gets hurt. And then you say, hey, school, you didn't follow the law. Okay, so you're responsible. But bullying and harassment involving a child with a disability, whether they have an IEP, a 504, or they don't have either of them, but the school knows that they have a disability, just not got around to a 504 or anything. Child who is bullied and harassed by peers and the school doesn't do anything, that is called deliberate indifference. And because that is creating a hostile learning environment for the child. When there's a hostile learning environment, then the child is being denied a FAPE because they're not concentrating. They're thinking that they're going to get beat up after school. They know that someone's going to harass them. They're not focusing. Chances are they're not going to want to keep coming to school. So that is a hostile learning environment. That is actionable with the Office of Civil Rights. It is actually also actionable with due process. I don't know, I'm sure I filed but so you can go to an administrative law judge if the child has an IEP and that child's being bullied and harassed, and that's a denial of FAPE.
And it's also with OCR, Office of Civil Rights, you can make an argument about denial of FAPE in the OCR complaint. It's one of the few times you can.
And so charter schools, they are public unless they don't get funds. Okay, there's only one school in Arizona I know that doesn't get funds, but otherwise they're all nonprofit and they receive federal funds. So they're kind of semi-autonomous. They have their own rules. You have to wear costumes, uniforms. Okay, there's a contract. It's open to all children. Yes, it is open to all children. Yeah. And they must comply with federal law and regulations. So the charter schools are not allowed to ask if your child has an IEP, 504, or a disability when you are applying for admission. However, once you're accepted, then they can ask you that on the enrollment form.
And if they don't have room for you and it's not your home school, then they could say they're at capacity and they're not going to take your child.
You can file complaints, and now the Arizona Department of Education has a form online that you can file complaints on open enrollment. Okay, so what if you do have a dispute or dispute resolution? You don't always need an attorney, but these are some of the examples that we deal with. I mean, I could, just calls every day. If your child was suspended for 2 days, nothing we could do.
Anything less than 10 days, really, there's not much we can do.
But so these are just some of the examples. And as far as like, if you need just a good IEP and everything's going smoothly or kind of smoothly, you can get a non-attorney educational advocate to help navigate the system too. So there are different kinds of violations, substantive versus procedural. Is your head spinning? My head's spinning, and I do this all the time. So procedural means it impeded the child's right to a FAPE. What does that mean?
That the child was not allowed to access the curriculum, or significantly impeded the parents' opportunity to be involved in the process.
Decision making.
So, yeah.
What? Oh, yeah. So like, okay, a procedural violation is school, the federal regulations, the IDEA and the federal regulations which implement the IDEA say you have to give a meeting notice, and you have to say on the meeting notice the time, location, who's going to be there. Okay. School doesn't give it. Procedural violation, right? Right. But
It's not.
the teacher tells it, hey, you know what? We're going to have an IEP meeting next week. Can you come? Yeah, I could come. Mom goes, they have an IEP meeting, develop an IEP, everything is fine. Procedural violation, yes. No harm, no foul. Can't do anything about it. Okay, so the procedural violation is only actionable. In other words, it would deny a FAPE only if the school didn't give you a meeting notice, had the meeting without you. That's a huge violation, because then you weren't allowed to participate in the DM, the decision-making process. Okay, that's just one example. Then you have, or deprive the child of an educational benefit because you didn't know about the IEP, and so it didn't include everything you would have wanted in the IEP, for example. Substantive due process, by the way, is substantive violation is the IEP doesn't meet the child's needs. So on the face of it, if your child has autism, but it doesn't include, say, speech and language goals and communication goals, that's not meeting your child's needs because, well, autism means one of the factors is that the child has problems with communication. So you have to address that issue. So these are ways to resolve it. If you have contentious IEPs, just ask the school district if they will go to the Arizona Department of Education, the AD, and ask for a facilitator. And that's someone who's trained to conduct these. And
No cost.
no cost. Schools don't always like it. Why? I don't know. Scottsdale years ago, they had a psychologist who would conduct these, and I thought she was fabulous. Of course, every IEP meeting I go to, right, is pretty fabulous.
Pretty much.
So, but that shouldn't be. That shouldn't be. And sometimes I will tell you, believe it or not, there are a couple of attorneys in Arizona who, for the schools that, if they know, I'm representing the parents and I don't want the parents to have to pay me to go. I say, can you go? And they go because they'll attend because the school district doesn't always know what it needs to do. And so there are actually attorneys that I trust to go, even when the parent doesn't have an advocate or an attorney. Mediation is another one. You don't have to, you could do mediation if you file a due process complaint, but you could ask school district, hey, let's go to mediation. They'll assign a mediator. There's like a handful of mediators. One of them is an attorney, the others are not, but they're really well trained in mediation. And they can usually resolve it. State complaints, you have 1 year to file those. Due process complaints, you have 2 years. Sometimes you realize you've had a state complaint, which is mostly for procedural issues, and it's 13 months. Well, you stop. You can't file a state complaint unless there was a reason you didn't know about it for a year.
Procedural safeguards.
Right. Oh yeah. See, those procedural safeguards, they may not mean anything to you. They mean the world to us, because if you're not getting those, that extends, Emily, you're going to love it. That extends the actual statute of limitations because you don't know your rights. So if the school was doing things bad and you didn't know for 3 years because you didn't get your your procedural safeguards notice, we could go back past 2 years. Office of Civil Rights, 180 days, and I mean 180 days. I do not mean six months. When you file that Office of Civil Rights complaint, which you do online, it will say, did your incident happen? And they calculate it for you to the day,
because they know what day you're filling out the form.
And then personal injury, we don't do personal injury, but we refer you to, but we can't refer if you have an emotional, if your child is emotionally upset, if something happens, it has to be, the attorneys we know will only take serious physical injuries. And then there's a statute of limitations on that. I shouldn't say it doesn't apply, it applies, but for a child with a disability, you have to give notice to a public school, including a charter school, within 180 days of when the disability ends. It doesn't end, but parents sometimes have a claim for their child's injury. And then you have to do what's called a notice of claim. Oh my God, I got it. Wait, I have a question and answer. Oh, here comes that advocate again. All right, she's so good. I like when she asks questions because she is wanting me to tell everyone. What if a child has a medical diagnosis of autism and a parent wants it recognized by the school, but he or she, the parents? Oh, he or she is being disruptive and aggressive, and the school is telling the parent the data indicates an eligibility of ED versus autism. Oh, yeah, those are, okay, so here's what the law says. The law says, basically, we don't care what the label is. All right, you will get what your child needs based on what their needs are. So if you have an autism medical eligibility from a developmental pediatrician, that is not an educational eligibility. Okay, so you've got people like Elon Musk who have autism, but I guarantee you he didn't have an IEP. I guarantee you wouldn't have been eligible. Does have some social emotional behavior issues, so maybe he would. But anyway, if the ED, schools will sometimes say the ED predominates. Okay, so you cannot have both. That is the one thing where, even though in the real world you can have autism, emotional disability, there is a law in Arizona that says, I have to look it up, but you cannot have both on the match.
On the eligibility. You can't be eligible for both.
Right, can't even have it secondary.
Right.
So it has to be one or the other. And I know that sometimes and I'll look at a report. I just got something where the kid has ED and the parent wanted autism and the parent got an IEE and the IEE says ED, and parent says, and I read it both ways and I say, I'm sorry, it can go either way. I can't say that is definitely autism. So what's the difference in deciding factors? The people,
the team, and obviously the school district has final say.
Right. So if you have an IE, you want your IE person there. Okay. I mean, I had a case with a school where they didn't want to find the kid eligible. They said conduct disorder only, conduct disorder, conduct disorder. And I said, no, you know, my feeling on conduct disorder is there's a reason for it. There's a behavioral issue. That turned around because, well, I'm not going to say who it was, but someone found a specific learning disability. That's how we got it. Okay. But the bottom line is that it depends on the team. So one team would decide one way, one team would decide the other, but you have to give examples.
Well, and ultimately though, if you're getting an IEP for under any category, you're entitled to any services. So why do you really care? Except I know ED has a stigma.
It has a stigma. Yes, it has a stigma. And it's between ED and OHI also. If the kid has a depression and anxiety, I would prefer OHI only because of that stigma that general education teachers perceive that ED kid as being bad. And that always bothered me about general education teachers. But anyway, because my kids were always ED. And so also empowerment scholarship account, you get more money, the autism. And so that's why a lot of parents want it, and schools know that as well. So, you know, we will push for whatever it is, but it depends also. We had a kid for ED, but another question. I had the child had been in RTC, so I had the people from the RTC actually talk and were very compelling. So you really want outsiders who might be able to talk about it, who have seen the child in another setting, but in an educational setting. Oh, okay. So I'm just going to read this. My 8-year-old son has an eye appointment tomorrow. Child has some challenges and doesn't focus. I don't know if vision therapy will help him. Anything I should bring up with the ophthalmologist in the school to provide the service? Laura, you talk about it because your kid had that.
Yeah, what you should bring up is, tell them that there might be some behaviors that might interfere with the actual test. But you want to, the things that you're looking for, especially, well, depending on what the vision problem is, sometimes tracking. So students that take those tests, we have to bubble in the Scantrons. I don't know if they're still doing that, but they were doing it when my kid was little, and he couldn't go from the document to the answer page and keep track of what it was. So things like that are important. So if you have any examples of that, I would bring it. If you have any examples of anything that shows, eye vision problems spatially, pictures that they're not staying in lines, that's stuff that you would want to bring with you to the appointment.
So if the ophthalmologist recommends vision therapy, then you bring it to the school, but you want to make sure that there's an educational component where it actually describes that he's not able to track, he's not able to copy. It could affect your visual motor, but that's a lot of times you'll ask a child to copy a 3-sided figure, a geometrical figure, and if they can, it could be occupational therapy, it could be, but it could also be that the vision tracking. If you want to email us, I will give you names of 2 people, and I just don't want to do any endorsements here. One who's an optometrist who saw Lori's child, and also an occupational therapist who also deals with those vision tracking issues. That's it. Any other questions? Because I'm not the last slide.
Out of time.
I'm out of time. You don't know how to show. Okay. That's it.
So thank you guys so much for amazing information. And it's a good thing you're from New York so that you can talk fast, because otherwise we never would have gotten through all of the materials. So always a pleasure to have you guys, to see you guys. I hope to see you soon in person at some conference or event that we're both at. Thank you to all of the attendees. And this was recorded, so we will be able to send that out, as well as I'm sure that Hope and Lori will post it at their website and their social media, as we will as well. So we wish everybody the best. Stay well. Thank you again, and we hope you will join us next month. Thank you so much.
Emily,
Thanks
for
for
this
having
great
us.
service. Thank you.
Bye.
Thank you.